Good morning. Our next case is State versus Beck, and we'll hear from the appellant.
Good morning, Mr. Chief Justice and Associate Justices, and may it please the Court. My name is Rob Ennis, and I represent the state in this matter, as both the appellant and the appellee in this case. I plan to address both the appellant and the appellee issues, but would like to reserve 8 minutes for rebuttal, please. The case is before the Court based on the state's appeal as of right from the dissenting opinion at the Court of Appeals on the issue of whether the evidence was sufficient to send 2 separate conspiracy charges to the jury. The case is also before the Court based on this Court having granted the defendant's petition seeking discretionary review of the issue of whether the Court of Appeals erred by not remanding for resentencing the undisturbed armed robbery conviction that the trial court had consolidated for judgment with the conspiracy for armed robbery conviction the Court of Appeals had vacated on appeal. So turning to the first merits issue, the Court of Appeals in this case, its decision should be reversed for several reasons. Primarily, the Court of Appeals appears to have not properly applied the correct review standard in assessing the sufficiency of evidence to send charges to the jury. Under this Court's well-settled precedent, the standard of review when on a motion to dismiss for insufficiency of the evidence, all of the evidence must be viewed in the light most favorable to the state, giving the state the benefit of all reasonable inferences and any contradictions in its favor. On the issue of whether the evidence was sufficient to send 1 or 2 conspiracies to the jury, this Court has instructed in Tirado and in Stimson, which this Court affirmed per curiam the Court of Appeals decision in Stimson, that this principle applies when assessing the question of whether the evidence was sufficient to send 1 or 2 conspiracies to the jury. Conspiracy is a unique inchoate offense. Unlike attempt and solicitation, it does not merge into the completed offense. Conspiracy is a separate conviction for which a defendant can be punished separately for conspiracy and the completed offense. Ordinarily, it's challenging for the state to prove the scope of an agreement. Criminal conspiracy, of course, being an agreement with the defendant and another person to commit an unlawful act or to commit a lawful act unlawfully. Here, we're only concerned with the first prong of that. But conspiracy is unique in that the crime is complete upon agreement. The actus reus of the crime is the agreement itself. And so the agreement is really what dictates whether there's 1 or 2 or multiple conspiracies. And in this Court's precedents established that when we have a situation like here where there's evidence defining the scope of the agreement, the first agreement, and the scope of the second agreement, then the question of whether there's 1 or 2 conspiracies is really not all that challenging. And what I mean by that, I guess, is we have direct evidence here and circumstantial evidence that establishes the very first agreement reached, and therefore the first conspiracy completed, did not encompass the separate crime of committing felony, breaking or entering. Whereas the second agreement reached, the rational jury could infer, viewing the evidence in light most favorable to the state, that the defendant had to reach a separate agreement to commit breaking or entering that had not been conspired the first time. This case, as identified in the state's briefs in this case, is indistinguishable from this Court's decision in Gibbs. In Gibbs, this Court held that a trial court does not err by sending 2 conspiracy charges to the jury for separate crimes if a rational juror could infer that the defendant entered into 2 separate agreements that encompassed different offenses. And so in Gibbs, just a real quick summary of the case there, the defendant, his girlfriend Gay, and his girlfriend's twin sister Doris entered into an agreement to murder the Ferrises. And at the time they entered into the agreement, the conspiracy was complete, and the separate crime of committing first-degree burglary against the Ferrises was not included in the scope of that first agreement. It was only a few weeks later that the defendant and Gay alone, as they were traveling to the Ferrises' house in order to perpetrate the planned murders, this court concluded there was substantial evidence from which a rational juror could infer by their conduct that they entered into a new separate conspiracy to commit first-degree burglary. So this court's decision in Gibbs was really founded on three basic principles. The first is there was substantial evidence that there were two separate agreements. The first agreement was separated in time by a few weeks, I think 2 or 3 weeks. The second is that the scope of the first agreement at the time the conspiracy was complete did not include the separate crime of first-degree burglary. It only included the conspiracy to commit murder. And the third major point for this court's decision in Gibbs was that the co-conspirator, Doris, was charged with conspiracy to commit murder, but she was not charged with conspiracy to commit first-degree burglary. And that's exactly what we have in this case. In this case, there's sufficient evidence to show that the first agreement reached for purposes of this analysis, we can say at the latest was among the defendant, Silva, Holloway, and Baker to commit armed robbery against Bershears and Trevette. And at the time that first agreement was reached, there was no evidence that the agreement encompassed the separate crime of committing breaking or entering. Indeed, Baker's testimony suggests that the initial plan, the defendant, Silva, and Holloway did not intend to go to Bershears' house, but they wanted to meet somewhere else. And so under Gibbs, because the first agreement reached when the first conspiracy offense was completed did not encompass the separate crime of breaking or entering, but the substantial evidence of the defendant's conducts leading up to the actual target, the completion of the target crime, a rational juror could infer that a new agreement had to be reached that involved now the separate crime of breaking and entering into Bershears' apartment, even if that agreement was reached in furtherance of the first conspiracy or that target crime was perpetrated in order to accomplish the criminal objective of the first agreement and conspiracy. And so that's exactly what happened in this case. And so for those reasons, for that main reason, the Court of Appeals opinion should be reversed because it conflicts with this court's decision in Gibbs.
Can I ask you a question? Like sometimes there's, there's these heist movies where these criminals have come up with although they're the protagonists of the movie, but they come up with these really complicated plans to steal something, and then it all kind of goes wrong as they're trying to, and so they come up with a bunch of other ways that ultimately still get to the end goal of, stealing whatever it is, but they've committed a bunch of other crimes along the way. I mean, so in your view, with the interpretation you're saying this court has taken, what if they're very chatty and let's say they're being recorded, so you have an agreement on the front end to come up with some plan, and then as things change, instead of breaking into this building, they steal this delivery truck and they do this. Are you going to end up with, in a case like that, under our state law, 50 separate conspiracies? Is that your view of how that works?
So, Your Honor, I guess it just depends on what the evidence shows the scope of the initial agreement was versus what second or third or other agreements would be. So if the scope of the first agreement was just to rob Bob, and then they later come together and decide that they have to commit mail fraud in order to complete the crime of murdering Bob, then that would be a separate conspiracy. I guess my understanding of this court's case law is that it's separate conspiracies that encompass different crimes. So the crime is the conspiracy. It's the agreement to commit an unlawful act. And so each time an agreement is made to commit an unlawful act, I think the only limiting principle, I guess, would be if it was a situation like a continuing conspiracy, like what the Court of Appeals here kind of concluded, that there was one continuing conspiracy. The Court of Appeals' reliance on the cases it cited, though, are misplaced for one simple reason, in that in those cases, they were conspiracies to commit the same crime. So Rozier, for instance, was a big case that the Court of Appeals here relied on. In that case, Rozier, the Court of Appeals panel said the first agreement was to, in that case, there was an initial agreement for the defendants to sell 4 ounces of cocaine to an undercover officer. On June 6th, I think it was, they sold only 1 ounce, and they said to the officer, okay, the rest is coming soon. And then on June 15th, they sold the remaining 3 ounces. And in that situation, the defendant was charged with conspiracy to traffic in cocaine on both of those dates that he sold and transferred the cocaine to the officer. The Court of Appeals determined that was really just one agreement to sell 4 ounces of cocaine to the officer. And so it vacated the second conspiracy on the basis that was just a continuation of the very first agreement to sell 4 ounces of cocaine. That's not what happened in this case. This case, we have different crimes that are being agreed to. And so, yeah, I guess that would be one main reason why the Court of Appeals decision is wrong and conflicts with this court's decisions in Gibbs and Gay. And then, Tirado and Stimson are also illustrative in that in those cases, again, re-emphasizing the idea that even if this were a close case, the issues should be submitted to the jury. If it's a question as to whether there's one single conspiracy or multiple conspiracies, this court has expressed its preference to submit the issues to the jury.
And Counselor, along that line of discussion, the way at least it appears in this case, that the Court of Appeals felt very bound by its own decision in Beck because there was the same objective involved. Could you comment specifically on that case, since that appeared to have been very determinative for the Court of Appeals?
Sure, Your Honor. And could you just clarify what case in particular?
The Fink case.
Oh, Fink?
Yes, okay. Because I believe the language was something along the lines of if the objective is the same, and I think that is in line with some of the other cases you were talking about, but I know that was very it appeared to inform the court's decision, the Court of Appeals decision. So if you could make a comment about that, I would appreciate it.
Sure, Justice Berenger. Yeah, so that does go in line kind of with what I was saying. All the cases the Court of Appeals relied on, including Fink, were situations in which there was conspiracy to commit the same crime. In Fink, I think it was conspiracies to commit armed robbery against the same person. There was an attempt on one day, the plan was thwarted by police, and then they came together and tried to rob the person again the second day. The defendant was convicted of 2 conspiracies to rob the same person, and the Court of Appeals determined that was just one continuing conspiracy to rob this person, and the criminal objective, I guess, was the same, to rob the person. I guess a difference with Fink, and I could actually be mistaken, that could be Medlin, and I apologize if it is, but Fink, it would be the same thing in which there was it was an agreement to commit the same crime. But yeah, so the criminal objective part, I guess, I think the Court of Appeals did find that was very persuasive, but under this court's decision in Tirado, for instance, that's just one of several factors that should be weighed in determining whether or not the evidence is sufficient to send multiple conspiracy charges to the jury. I think Tirado lists the objective of the conspiracies, and in this case, we can say the first agreement, the objective was the armed robbery of Bershears, and the second agreement, the objective was to break and enter into her apartment. But so objective of conspiracies is one, the time interval between them, number of participants, number of meetings, and the nature of the agreement or agreements. Those are the factors that Tirado identified as things that a jury can consider as to whether or not the evidence showed one conspiracy or multiple conspiracies. So the Court of Appeals here seemed to place an undue emphasis, I suppose, on the criminal objective part of it.
Well, and just one follow-up, and it really relates to the hypothetical that Justice Dietz posed. One way, or at least the way I perceive that the Court of Appeals was looking at this situation, is there was an overarching objective to rob. And as a result of changed circumstances, the breaking and entering actually caused that to move forward. It became necessary so that they could rob them, they would have to break and enter. Could you comment on that position, as I said, as it appears in the Court of Appeals.
Sure, Justice Berenger, and I think that kind of goes back to what I was trying to at least express with this court's decisions in Gibbs and Gay. Just as in Gibbs and Gay, the overarching conspiracy, if you were to use it in those terms, I guess, were to murder the Ferris family. But still, there was a separate conspiracy that had to be hatched, which was committing first-degree burglary in order to perpetrate those murders. Just like in this case, if the overarching conspiracy was the armed robbery of Bershears and Trevette, there's still circumstantial evidence to show that they had to have come together and entered a different agreement to commit breaking or entering in order to perpetrate the goals of the target crime of the first conspiracy. In a lot of cases, too, we don't have the benefit of direct evidence defining the nature and scope of the agreement, which really, that's the essence of the crime of conspiracy under this court's law. Well, conspiracy is a common law offense, and how the offense kind of developed in North Carolina, it's the agreement that's the actus reus. And so that's the thing that really makes, it's the most defining feature of the crime. And so in this case, we're lucky in that we have a co-conspirator who was able to provide us, and we also have text messages, and the victim herself, who were able to give us enough information that we could kind of define the scope of what the initial agreement was, which did not include the separate crime of breaking or entering. The circumstantial evidence that when Silva arrived at the parking lot after he called Bershears and hung up, he immediately drove away. And then Bershears is texting Silva saying, "Oh, I could have come down if you want. I just wanted to weigh the drugs in front of you." A reasonable juror could infer that the original plan was for Bershears to come down to the parking lot where they would conduct this pseudo-drug deal in order to rob her. And it didn't involve committing the separate crime of breaking or entering. But then after 30 minutes of Silva driving around, he eventually returns to Bershears' apartment. A rational juror could presume that within those 30 minutes, they were trying to figure out, how they can go about, I guess, accomplishing the purpose of the first agreement. And just like in Gibbs and Gay, it's circumstantial evidence that they had to reach another agreement to commit a crime, even if it was the sole purpose of it was in furtherance of the criminal objective of the first conspiracy.
So just out of curiosity, how would you analyze this if, for example, the evidence showed that the co-conspirators, what they agreed to was, we're going to rob Bershears and Trevette no matter what we have to do?
Well, that would raise an interesting, we'd be in a different position, I guess, but that would raise an interesting question. I would say that would still just be one conspiracy to commit robbery.
So that, in your view, wouldn't change our analysis? Is that?
No, I don't think so. And the reason I don't think so is because in this court's decision in Gibbs and Gay, this court specifically identified the fact that at the time the agreement was reached among Gibbs, Gay, and Doris to murder the Ferrises, it was a non-specific plan. They didn't have any idea how they were going to do it. But regardless, this court said the crime of conspiracy to commit murder was complete at that time. North Carolina doesn't require an overt act like other jurisdictions, and I think the Model Penal Code does. Even still, the overt act requirement, typically it can be satisfied by a very minor step that's not comparable to the substantial step usually required for an attempt. For instance, in this case, if we did have an overt act requirement, which again we don't, the act of the defendant getting into the car with Silva and Holloway and then driving to Boone, as the texts indicated their plan was to commit armed robbery in Boone the next day, could be considered a substantial step in the formation of the conspiracy. That's why I use that as kind of an example of when one agreement was formed. And then another agreement was formed when Baker became a participant of the conspiracy, and they actually identified the victims who they were going to rob. And then, as I said before, there was another implied agreement that was formed among, Baker was not a participant to it. So just like in Gibbs and Gay, where Doris was charged with conspiracy to commit murder, but not conspiracy to commit first-degree burglary, Baker here was charged only with conspiracy to commit armed robbery and not conspiracy to commit the breaking or entering. And Baker's testimony also gives inferences that I think he said that he initially lied to police because I think his words were, I wasn't sure how I would be affected by the decisions that were made at the end of the process, from which a rational juror could infer that Baker wasn't involved in the agreement to commit breaking or entering in order to perpetrate the robberies. And there's,
I'm sorry, but if I can just follow up on that hypothetical, and I know it's not the facts here, but if the initial agreement had been that we're going to commit armed robbery and we're going to break into the apartment to do it, is that two conspiracies?
well, Your Honor, I hesitate only because this court's decision in, I think it's pronounced Gell, G-E-L-L, that's cited in the state's brief. In that case, the evidence seemed to indicate that at the very same time, the defendant and his co-conspirators had agreed to murder and rob the victim. And then during the same transaction, they had murdered and robbed the victim, and he was convicted of both conspiracy to murder and conspiracy to rob. On review, this court determined the evidence was sufficient to sustain both conspiracies. So that's why I hesitate when I answer your question, because it seems like under Gell or Gell, however you pronounce it, that perhaps still would be two separate conspiracies. But
So then why would we even have the Tirado factors that we're supposed to evaluate to determine whether or not there are two separate agreements? Why would it even matter?
you're right, Your Honor. And so I would say that probably Tirado's analysis would control over Gell's or Gell's, which occurred prior to that. And Tirado also was citing Court of Appeals cases which had more experience analyzing these issues than I think this court may have, just by virtue of the number of cases that get appealed to the Court of Appeals. And so, yeah, under Tirado, the focus is more on the totality of the circumstances, using those factors I mentioned before, like the number of participants, the time, the criminal objectives, the number of meetings, and things like that. But still, when we have a situation where there's a defined agreement, we know the parties privy to it, and we know what crimes are encompassed in that agreement. That kind of informs whether a second agreement would constitute a separate conspiracy or not, as this court determined in Gibbs and Gay, which is kind of what we have here. And so I'll discuss a little bit, just if there are no further questions about the first issue, I guess, so just to sum up, the Court of Appeals in this case erred because it didn't really view the evidence in the light most favorable to the state as it's supposed to have done when reviewing motions to dismiss for insufficiency of the evidence. When it's viewed properly like that, there's sufficient evidence to show that the defendant entered into two separate agreements at separate times with different parties that encompass different crimes. And under this court's decision in Gibbs and Gay, that's sufficient to send both conspiracy charges to the jury. And in this case, both conspiracy charges to the jury were sent. They were instructed that in order to find him guilty of conspiracy to commit armed robbery, they have to find he entered into an agreement with others to commit armed robbery. And they were instructed that to find whether he conspired with others to commit the crime of breaking or entering. And the jury found both, the defendant was guilty of both of those offenses. So yeah, if there are no further questions, I guess I'll just briefly talk about the petition for discretionary review issue with fair sentencing. And as an initial matter, if this court agrees with the state that the evidence was sufficient to send both charges to the jury, it need not address this issue as to what the proper appellate remedy would be. But let me back up, I guess. That one other thing I want to talk about, if this court does conclude that there was evidence of only a single conspiracy, and the Court of Appeals erred by deciding which conspiracy to sustain and which conspiracy to set aside. It's interesting with the Court of Appeals opinion, I think 3 or 4 times they describe the evidence as showing conspiracy to commit armed robbery against Brashears and Trevette. And they say, oh, the agreement to break and enter didn't convert the original conspiracy into a new conspiracy or a separate conspiracy. So the Court of Appeals is kind of interpreting the evidence to say if there was a single continuing conspiracy, it was the conspiracy to commit armed robbery. Yet the Court of Appeals still decided to vacate the conspiracy to commit armed robbery conviction on the sole basis that the defendant had perpetrated the substantive crime of breaking or entering immediately before he perpetrated the substantive crime of armed robbery. And under this court's precedents, for instance, in State v. Arnold, decided in 92, and the conspiracy, the substantive charges, crimes, whether they're committed or not, have no bearing on the conspiracy convictions. So it follows that whether the defendant committed one substantive crime before another or after another should have no bearing on the conspiracy convictions in this case. And so if this court were to find there was one continuing conspiracy, which the state would say that there was definitely substantial evidence to send both charges to the jury, then it should instead vacate the conviction for conspiracy to commit breaking or entering, and not the conspiracy to commit armed robbery. And briefly, with the Fair Sentencing Act issue, the defendant here has the burden of showing the Court of Appeals erred by not remanding his undisturbed armed robbery conviction for resentencing. The defendant has not satisfied that burden in this case. There's a statute that grants the Court of Appeals, appellate courts, authority when granting relief to affirm one but not all charges in a judgment, and then, if it finds it appropriate, affirm the sentence. So we have statutory authority for the Court of Appeals to do this, and the defendant has cited to no precedent from this court that the Court of Appeals' decision not to remand the undisturbed armed robbery conviction for resentencing conflicts with. And so that's the defendant's burden to show, and he's relied on cases like Moore, Wortham, and Brown, and as explained in the state's appellee brief, those cases are distinguishable for the main reason that they were decided under the Fair Sentencing Act when consolidating convictions for judgment. Each separate conviction could attribute to the overall length of the combined sentence imposed. Under structured sentencing, consolidated convictions cannot contribute to the overall sentence length imposed, and sentence has to be imposed based solely on the most serious offense. If there's no further questions, I would like to reserve the remaining time for rebuttal, please.
Thank you, counsel.
Thank you.
We'll hear from the appellee.
Good morning, Your Honors. May it please the court. My name is Sterling Rozier. I'm with the Office of the Appellate Defender, and I represent Mr. Beck. And as the state mentioned, this case is somewhat complicated, so I will try to address both the appellee and appellant's argument, but I won't be reserving any time for rebuttal. Now, the state says that it's easy to figure out whether there was one or multiple conspiracies here. And I think that they're right about that. I think it's easy to find that there's a single conspiracy. All of the case law supports that conclusion. There was a single conspiracy to rob a drug dealer. And the decision to break into the apartment in order to accomplish that goal does not change this into two separate conspiracies. And the Court of Appeals majority correctly recognized this. And applying the factors that are identified by this court, which we have for a reason, right? If the state were correct, as I think Justice Earle has asked, that every new agreement to commit another crime was a new conspiracy, then we wouldn't have cases like Rozier and Medlin and Wilson and Tirado. Tirado would be very short. But instead, we have factors that we have to consider. And the factors that we have to consider are the nature of the agreement and the objectives of the conspiracies, the time interval between them, the number of participants, and the number of meetings. And in this case, all of these point to the existence of a single agreement. And the most important of them is the objective. In other words, what was the plan, right? And it was a single plan to rob Bashir's. The decision to break in and enter into the apartment was just undertaken so that they could do that. And this is exactly what the Court of Appeals majority was talking about when it said that even though the robbery conspiracy evolved into a breaking and entering plot, the criminal purpose remained the same. And I think that listening to the state's argument, I heard them say a couple of times, they were done with the robbery, and then they formed a new plan to break and enter. And the question I have when I hear that sort of statement is, well, what did they break and enter to do? Right? They didn't break and enter just to smash into the house and then leave. Right? They broke in so they could rob her. The whole point of all of this, all of these decisions, all of these actions, was to accomplish this robbery. And the state seemed to recognize this at trial. Right? During closing, they referred to a plan, the agreement. They said this isn't something where they planned to do it, but something happened and they got stopped. They actually went in there and robbed her. So now the state argues that there was a second agreement because there was some sort of break in time, right, where they were thwarted from carrying out the robbery the way that they had planned it, and that this break in the plan was sufficient to make their sort of regrouping, their evolving plan a second agreement. But I disagree with that. I think this was a continuous interaction. From the moment Mr. Beck got involved on April 26th or 27th to the end of the robbery on April 27th, right, we're talking about a period of about a day. And the time between Silva showing up in the parking lot and getting spooked and leaving and then coming back and going into the apartment was about 20 minutes. Right? That's not a significant break in the plan. But even if it were, it's not dispositive because of the other factors. You would have to consider what kind of breaks were present in other cases. And in Lawrence, you have a plan to rob a drug dealer that gets thwarted because the neighbors spook the conspirators, and they leave and they come back and they get a new person involved. At that point, they get the defendant involved, and then the police are called and they flee again. And some 36 hours later, they come back with sort of their final attempt, and all of that was a single conspiracy. Medlin involved several robberies over 4 months where they would complete a robbery and sit around and hand out the stuff they stole and then decide what their next robbery was going to be. But again, that was a single conspiracy. And Rozier, I don't know if it's Rozier or Rozier, and no relation, but Rozier involved 2 drug deals over 6 days, right? And the first was thwarted because they weren't able to sell as much of the drugs that they wanted. But it was still a single conspiracy. And I think this really goes to show that, not only does an agreement to commit another crime or an additional crime change it into multiple conspiracies, but that what we really look at of all of these factors, the most important one is what were the objectives.
Why isn't Gibbs controlling?
I think that Gibbs is distinguishable because, Your Honor, of some of the things that the state highlights in Gibbs, and I apologize, I'm trying to find my notes on Gibbs here, but as the state says, all of the participants in the former conspiracy did not agree to the separate conspiracy in Gibbs. And I think the state and I disagree about whether all of the participants in the purported former conspiracy and the subsequent one agree, because I think our case law is pretty clear that when you're deciding whether there are one or more agreements, you look at the indictments. And the state talks a lot about what Baker was charged with, but what matters under Griffin and Rozier are who was the defendant, right? What do the indictments say Mr. Beck conspired with? And in the indictments in our case, for both conspiracies, he was charged with conspiring with Holloway and Silva. And those don't change throughout. And then Gibbs also has that weeks later, right? They originally decide between Gibbs and Gay and Doris that they're going to commit a murder, and then weeks later, 2 of them decided, okay, it's time to do the murder. Now we're going to do this. Here's how we're going to do it. And I think that based on the totality of the circumstances in that case, those factors show the existence of separate conspiracies, but that's not what we have here. We have basically one ongoing meeting between these people, right? It appears that they pick Beck up on the 27th or maybe the 26th, and they drive to Boone to do this robbery. And they're together at all times while they're doing it. It's a day or two at most. It's not weeks. And then I guess the final thing I'd say about Gibbs and Gay is that they were decided before Tirado, and I think that Tirado really sort of crystallized the factors that we're supposed to be looking at. But while we're talking about the state's cases that they rely on, I think it's important to also consider the other cases that they cite, Stimson and Tirado. And I think that the cases that the state cites with Gay and Stimson and Tirado, they are very illustrative, but they are illustrative by how different they are from the facts of our case. In Stimson, for example, there was no overarching agreement, right? There was no plan to commit a robbery as there was here. In Stimson, the Court of Appeals said the victims and crimes committed arose at random and by pure opportunity. And so that would be like if they conspired to rob this drug dealer and show up in the apartment and then saw somebody walking across the street and said, oh, well, let's go rob them too while we're here, right? That might be, under Stimson, a second conspiracy, but that's not what we're dealing with. And Tirado, and the facts of Tirado are wild and terrible and nothing like what we're dealing with. And to sum it up very briefly, you had various gang members agreeing to steal cars and then kill the owners of the car and then go out and steal another car and then kill the owners of the other car and drive evidence to different places. And this court noted it's a series of meetings, a variety of locations and participants, and different objectives that showed that in Tirado it was multiple conspiracies. And again, that just isn't what we have here. We have the same three people trying to rob a drug dealer and deciding to break into the house when that was how they had to accomplish that offense.
And Counselor, could you clarify for me, and perhaps it goes back to your point about indictments, I believe I understood your friend on the other side to say that one of the factors involved is the fact that everyone was not convicted of the same crime, that there were differences in that regard. And so how do you reconcile that?
Well, 2 points. I think that what you're referring to is the question of whether Baker, the person who I think lived in Boone, who the three charged conspirators in this case, the three who I say are relevant, Silva, Holloway, and Beck, they contacted Baker. They said, hey, we're trying to do a robbery. Do you know a drug dealer? Can you set something up for us? He is not named in the indictments here, and I think that under the case law, it is clear that you look at who the defendants are accused of conspiring with and deciding whether the evidence is sufficient. In fact, there are cases where the state, I believe it's Fink, where the state it's Griffin, excuse me, where they're trying to do a drug deal, they're smuggling drugs into a prison. And there are apparently multiple people involved in this, multiple people bringing the drugs in, multiple prisoners receiving the drugs. And in Griffin, the court said, the state is talking about other people who are unnamed co-conspirators and saying that their participation changes this. And the court says that you have to look at the indictments. The indictments under which defendant was tried all allege the same co-conspirators. And so that's what we have here. And so we say that Baker doesn't matter here. But even if he did, or even if he was a conspirator, if we sort of credit that, the mere fact that multiple that members of the conspiracy may vary occasionally doesn't change this into multiple conspiracies. And again, that's from Griffin. A single conspiracy is not transformed into multiple conspiracies simply because its members vary occasionally. There was a point that I wanted to make, I apologize, I can't remember whose question it was, but about whether just the commission of a second crime changes it into a multiple conspiracies on its own. And I've already addressed that a little bit, but I did want to remind this court of the quote in Braverman versus the United States from the US Supreme Court that says that the one agreement cannot be taken to be several agreements and hence several conspiracies because it envisages the violation of several statutes rather than one. So no, just agreeing to commit multiple offenses does not on its own change the nature or the objective of the conspiracy. Your Honors, as to, unless you have further questions, I'm going to try to shift to the appellant's argument. Since we're getting a little bit low, I'm still happy to talk about whatever if you do have any questions. But the important question, I think, in this case, because I agree with the state, it's easy. There was a single conspiracy, and the Court of Appeals majority got it right there. But then it brings us to this question of, well, what do we do? When you have multiple convictions that are consolidated for judgment and you vacate some but not all, what do you do with the surviving conviction? And for years, the answer has been to remand the surviving conviction for resentencing. And the Court of Appeals didn't do that here. And this is the part where the Court of Appeals got it wrong, because the lower court ignored established precedent. And the state not only now argues that this remedy was proper, but it wants this court to announce a ruling that would upend 4 decades of precedent and practice and contradict legislative acquiescence and contradict the position that the state itself has taken consistently in other cases up until, I think, this brief for the past 4 decades. And it also ignores reason. And in support of this surprising position, the state doesn't really tell us much. We've described in our brief the Wortham Rule. I don't know that it's going to help to get into the history of all of that. I certainly am not going to be able to do it as well as we did in the brief. But to rebut all of that history, the state, at least in its brief, tells you that, well, Wortham was decided under fair sentencing and is no longer relevant. Because when the General Assembly enacted the Structured Sentencing Act, according to the state, they overruled Wortham. And this is surprising, because if it's true, nobody told the Court of Appeals that. They continue to apply Wortham. And nobody told the state, because they continue to argue that it's applicable. And they haven't brought it to this court's attention before. This court has not recognized the argument that the state's position is requesting. And structured sentencing became the law in 1994. So in 3 decades since structured sentencing supposedly overruled Wortham, nobody knew it. And the reason is because it didn't happen. And the one key flaw, I think, to the state's argument, despite everything that they cite, it really all comes down to discretion. Right? And they essentially argue that there was discretion under fair sentencing and there is no longer discretion under structured sentencing, and therefore the whole Wortham Rule and its premise no longer apply. But there is discretion under structured sentencing, and you only have to look at General Statute 15A 1340.17C and the sentencing grid. And you'll see when imposing a consolidated conviction for multiple offenses, you identify the prior record level of the defendant and you identify the class of the felony for the most serious offense. And where those meet, you see a series of boxes with 3 pairs of numbers joined by a dash, right? And that dash is discretion, because a judge, after they've identified the appropriate box for the most serious offense, gets to pick any number in that range, the low end or the high end or anywhere in between, and impose a sentence. And there is nothing in the statute or in the case law that the state cites that says that a trial court is not allowed to consider factors such as the seriousness of offense, the number of offenses committed, the prior record level. There's nothing that prevents a judge from deciding, I'm going to impose a sentence at the upper end of the presumptive in light of the facts of this case, including the fact that we have this number of convictions. And certainly the statutes don't say that, and Tucker doesn't say that, which is what the state really points to make this argument. And I think it's important to sort of look back or step back and consider what the state is really arguing for here. Because again, they're saying that 30 years ago, the legislature created a law making it illegal for a sentencing judge to consider consolidated offenses when choosing a minimum term. And as I've already said twice, I think now, the number of cases that continue to apply Wortham, and anecdotally, the number of instances where a prosecutor will say, Your Honor, we agree to consolidated sentences, but given this was a crime spree, and the number of sentences we'd like something at the top of the presumptive, or the number of times a judge says something similar, I think that it is common practice in this state for this to happen. It would come as a shock to the bar to learn that it is unlawful for a judge to consider consolidated sentences when imposing a sentence. And again, the legislature has seen the Court of Appeals continue to apply the Wortham Rule, and when doing it, announcing we cannot say that the same sentence would be imposed if there had been fewer consolidated convictions, and the legislature hasn't acted. And so the state wants this court to announce that for 30 years we have been imposing potentially unlawful sentences. And the post-conviction part of me rejoices at hearing that there may be a new discovery that there are 30 years of unlawful sentences. But it is wrong, right? This did not happen. The state's argument is unsupported by all of the things that we've talked about. Right? Consider the exceptions to the rule, right? I mean, this rule is very well established, and the only time that we don't apply the Wortham Rule is where the defendant received the lowest possible sentence, right? The bottom of the mitigated, or where the sentence was required by law, a life sentence for sentences where that's the lowest that it could be. And again, so the exceptions just show the existence of the rule and its continued application. And I think that this court should reject the state's request for all the reasons that we've discussed below, but also but also because this court shouldn't step into the role of a sentencing judge. This court, the appellate courts in general, should not undertake that exercise of discretion that is reserved by statute for sentencing judges. It is not the role of this court to look at a case and say, well, this sentence was imposed, but there was something wrong with it, so we're just going to pick a new one that we think is right. Your Honors, the decision to abandon Wortham was a mistake, and the state's request that this court not only affirm the mistake, but do it for reasons that weren't. The Court of Appeals majority didn't abandon Wortham because of what the state has told you in its brief, or what it brought up today. But to hold that Wortham was overruled by statute 30 years ago, unbeknownst to everyone, would be a mistake. This court should recognize the discretion awarded to sentencing judges, even under structured sentencing. And if there are no further questions, I would ask that this court affirm the Court of Appeals majority's holding that there was a single conspiracy.
Let me very quickly ask you, what about the state's argument that if there were only one conspiracy, the COA found the wrong one? It seems I've heard you argue that the armed robbery was the overarching or the continuing conspiracy.
Yes, Your Honor. Yeah, I think the state's right. on that point. I think that argument is not properly before this court, and if this court follows precedent as recently as 2 weeks ago in State v. McCoy, where it unanimously declined to address arguments that were briefed by parties because they weren't within the scope of the dissent, then this court would not address that argument as well. But having said that, yes, I think on that point and on that point alone, the state and I are in agreement. There any? No. Thank you, Your Honors.
Thank you, counsel. Rebuttal?
Your Honors, just a few points that I wanted to address from my colleague. He identified the fact that Baker wasn't identified in the indictments in this case. One reason that could be is because the defendant was indicted in September 2017 and Baker wasn't indicted until January 2018. That could be one reason why Baker was not in the defense indictments, for example. But also, there's no case law that says that a co-conspirator has to be in an indictment. And we see this from this court's decisions applying the co-conspirator exception to the hearsay, the general rule against hearsay. The co-conspirator doesn't have to be identified in an indictment in order for he to be considered a co-conspirator under the law. So as to the fair sentencing argument, or the argument that's on discretionary review, it's not the state's burden to establish that Wortham has been overruled or overturned. It's the defendant's burden to show that the Court of Appeals has erred. So the defendant's suggestion that the state is asking for this court to make some rule that seems so outlandish is really kind of misplaced, because it's not the state's burden, it's the defendant's burden to show error as the appellant in the Court of Appeals decision. And the defendant hasn't done so in this case. The general rule is a defendant has to show prejudice before he's entitled to a new sentencing hearing. And we see that in cases like this court's decisions in State v. Norris, or applying the Blakely rule. If a trial court improperly makes aggravating findings but still sentences in the presumptive range, the defendant isn't entitled to a new sentencing hearing where the trial court doesn't consider those aggravating findings that it found. So the defendant's argument about the discretion afforded in selecting minimum ranges to the trial court, there's no other situation in which that's an automatic reversal if something occurs that you could say impacted the judge's discretion, the sentencing decision, unless it's a situation in which the record affirmatively shows that the trial court considered an improper matter like the defendant's exercise of his right to a jury trial, that the presumption of regularity in a presumptive range sentence would be overcome. And also, the legislature has spoken on this. A defendant isn't entitled to appellate review of the issue of whether the trial and sentencing evidence is sufficient to support the sentence imposed if he is sentenced in the presumptive range. So the legislature contemplates not being able to challenge the particular minimum term a trial court selects, and for good reason, because that would be overstepping on the trial court's discretion.
Thank you, counsel.
Thank you, Your Honors.
Thank you to both.
And
Thank you. Mr. Clark.
Rise.